this down.
What crime did I commit?
Pardon?
What crime did I commit?
Alleged that you committed the crime.
I didn't commit that crime.
Resisting. If you want to interrupt me, I'll answer your question. But if you want to keep interrupting me, I'm not going to play that way. I'll answer your question. Court calls case People versus Dwight Miller.
Ashley Lonnie for the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Miller, who approaches your.
In this courtroom clash, the defendant, Dwight Miller, repeatedly demands a single answer. What crime did he commit? As the court attempts to maintain order, a clear tension emerges between legal procedure and the defendant's refusal to accept the charges against him.
Mr. Miller, can you please state your name for the record?
Dwight Miller?
Thank you.
And Your Honor, my belief is that my client does want to set this for preliminary examination. However, I am uncertain. He and I have had some conversations, and frankly, I believe he wants to make some statements to the court. I advise him against it, but at this point, I think he wants to talk.
So, we're understanding this is a criminal matter, right?
It is.
Okay, so basically, man, it stemmed from a falsality. All this whole thing, I was falsely arrested for something I never did. I got a sworn affidavit.
Sir, I'm sure your counsel has advised you. I'm going to advise you to not say anything else about the subject matter of the case.
Okay.
If you'd like it set for preliminary examination.
I want to challenge jurisdiction.
You want to challenge jurisdiction?
Yes.
Of whom?
Y'all have a jurisdiction of a case that doesn't exist against me.
On what grounds?
What crime did I commit?
Pardon?
What crime did I commit?
Alleged that you committed the crime.
I didn't commit that crime.
Resisting. If you want to interrupt me, I'll answer your question. But if you want to keep interrupting me, I'm not going to play that way. I'll answer your question. You're accused of the crime of attempted resist, or not attempted, but resisting and obstructing a police officer.
So we all aware that this never transpired, right?
I am not aware of that.
Okay.
Is that all you have to say?
Mm-hmm. Yes, sir.
So, Your Honor, I would ask Mr. Miller. Mr. Miller, I'm not submitting frivolous motions.
Can I get my affidavit put in on the record, please?
Affidavit.
My affidavit of the incident that transpired.
Your affidavit of what?
The facts in the case. My statement of what happened. Can I get it on the record?
There will be an opportunity if you so choose, if this goes to a further proceeding, for you to put whatever evidence you want into the court. But this is not the time to do that.
Really? So when is the time to put the evidence in there?
If you want it set for a preliminary examination, you'll have that opportunity. And if it proceeds to trial, you'll also have that opportunity.
So once again, I'll ask, do you want to set this for preliminary examination, Mr. Miller?
Sure.
Thank you.
Not really.
See, do you want to set it for prelim or do you want an adjournment?
Preliminary examination.
Thank you.
To your knowledge, all discoveries.
To my knowledge, yes, Your Honor.
People have their witnesses available the 24th.
Yes.
We could try for that date, Your Honor. If possible, I might ask to go one. No, let's do that date. Thank you.
All right. Preliminary examination in person will be set June 24th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Thank you.
You want to get the discovery? They will have evidence. I will make evidence.
Despite the defendant's persistent challenges, the court firmly reasserts control, clarifying the charge and advancing the case to a preliminary examination. The moment underscores a critical truth. In court, procedure prevails over protest, and answers come through process, not interruption.
In this intense courtroom moment, The defendant keeps asking one question again and again. What crime did I commit? From the very beginning, tension starts to build. Instead of staying quiet, he challenges the court and questions the case against him. The judge, trying to maintain order, asks him to stop interrupting and let the process continue. But the defendant doesn't back down. He insists that he was falsely arrested and that the case shouldn't even exist. At one point, he even challenges the court's authority, questioning its jurisdiction. This is where things become more serious. The judge remains calm and professional, reminding him that this is a criminal matter and there is a proper process to follow. Finally, the court clearly states the charge: resisting and obstructing a police officer. But even after hearing this, the defendant disagrees and continues to argue. He tries to present his own version of events immediately, but the judge explains that this is not the right stage. There will be time later to present evidence, either in a preliminary hearing or at trial. In the end, despite all the interruptions and challenges, the judge moves the case forward and schedules the next hearing. This moment highlights an important reality. In court, procedure matters more than emotion. No matter how strongly someone feels, the legal system follows a structured path. And in that system, answers don't come from interruptions. They come through the process.